You got to plead not guilty to the offenses. See about getting a bond set.
Good morning. Did you file anything for a bond?
Yeah, I filed a motion for speed.
So he's gonna enter some pleas in the motion, and then what about the new case?
New case is pleading not true, and if there's administrative things, we can go through that. I think that they've been doing a lot of prosecution. Or is it
Computers.
It's not my case, I'm just standing in for,
Ms. Murphy.
yes, yes, for this. I can't speak to what she intends to do.
I'm sorry, my screen is still loading. There. It's everybody's spinning. Oh,
I don't see the motion for the bond. We'd ask for 3 days. I'm not prepared to report for that advance notice.
Should have requested one in the letter, if not the motion itself, on the notice letter.
request for probation bond and speedy hearing
Revocation hearing, yes, sir.
was filed August 18th. Let me just go through this motion
It's
first.
the same one always filed.
Mr. You're Nathan Lamel? Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So I'm just gonna go through it.
All right, Mr. Lamel, in cause number 24 DCCR 0826, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of evading arrest or detention with the use of a vehicle, third-degree felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of burglary of a habitation, April 26th of 2025. And is that true or not true? You weren't arrested?
Well, he was arrested, but
That's what the allegation is. And I'm not, anyway, I don't know why they've changed them to just arrested, because being arrested isn't really a violation instead of committing the offense. All of a sudden, all these motions are different. Y'all might want to take a look at that. They're not alleging that they committed the offense.
I apologize, Your Honor. He was arrested, so that would be true, but I don't think it's a violation.
All right, so count 1, you're pleading true to? Okay.
You were arrested.
Count 2 alleges that you failed to avoid injurious or vicious habits as directed. I don't know what count 2 is either. No, just don't worry about it, because it doesn't say what it was. And so I don't think that is an accurate, I don't think I can go forward on count 2. Count 3 alleges that you failed to report to the probation office March 5th and April 9th of 2025. And is that true or not true? Count 3 is true. Count 4.
Just to be clear, I think what he said was it's true that he called in. So I don't know that he was.
Did you report or did you not report on March 5th or April 9th?
I think what he said was you didn't report, but you called in.
I don't need to know that. I need to know if you reported as directed on March 5th and April 9th of 2025.
Full plea contrary. I think he's not sure.
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true? That's marijuana, THC. Did you test positive on May 1st? Speak up.
Not sure.
Okay.
Not true.
Count 5 alleges that you were at a location other than your residence at 3:01 a.m. on April 26th of 2025. And is that true or not true? Count 6 alleges that you tested positive on May 1st of 2025 for alcohol. And is that true or not true?
Not true.
Did you enter your pleas of true to counts 1 and 5 freely and voluntarily? And because those two counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence.
I think you pled not true to not to 5.
1 and 5?
That's my understanding.
He
That's what I wrote
pled,
down.
No, 5 is 3:01 a.m. I thought he said,
Not true.
not true.
I wrote down not true.
oh, I'm sorry.
You don't
So,
play it true to number 1.
Right.
okay, so you're saying that is not true that you were at a location other than your residence at 3 o'clock in the morning on April 26th?
When you were arrested, that was your residence or wasn't your residence?
Oh, that was my reason.
He's saying it was his residence that he was
That's what I was
arrested at,
saying.
what he was saying. So it's not true.
Okay, count 1 then. All right. So I'm going to reset your case for a sentencing hearing. Obviously, the state can bring any evidence with regard to the allegations that you pled not true to. Also, y'all might want to make a note, go through if there's going to be any amended motions. Looks like I've seen several like this that need to be addressed.
Yes, ma'am.
It doesn't appear that the offense is alleged, Your Honor,
It's not at this point, correct?
but there's a non-prosecution file for that.
That's-
so
I don't-
may be
that's-
part of it.
All right, so we'll get an updated pre-sentence report in this case. And so Mr. Kimler filed a request asking that I set a bond in this case. Give me just a second before I get into that to go. I'm going to take a look, for the record, I'm going to take a look at the probable cause affidavit and cause number 25 DCCR 0744, which is that new case. So give me just a minute. Yes, ma'am, it's unagreed. I printed it. It's easier for me to read in person. Mr. Kimler, do you have any evidence with regard to that bond?
His ability to post the bond, Your Honor, is that what you mean?
Yeah, any evidence with regard to your request for a bond?
Well, just that he's on, I believe he's on the third, and, what's your financial situation? Not too good, you employed, or did you lose your job because of your arrest?
I had a job that I lost for the rest.
Where were you working?
I had just started. doing that.
I can't, if I, don't make me tell you to speak up again.
I would just say he doesn't appear to be an absconder, Your Honor. I mean, they're just 2 days. It seemed to be.
Well, my issue, I mean, regardless, I guess at this point, until we have more information about whether or not the complaining witness is going to go forward, is that it appears as though
Domestic dispute, Your Honor.
well, he had already been trespassed, warned by the officer, I believe that same day, left with his mother, and then the allegation is he came back and then was aggressive with officers. And that the allegation is that there was a broken a window that was broken and coming through a window, so that doesn't.
She's not I think the victim, the alleged victim's present, Your Honor, if you want to.
But I renew the state's position that we weren't prepared to go forward. In fact, on the bond today. In fact, there's a copy of that letter that Mr. Kimler references. You may have a copy there, but I don't have a copy filed. We asked for at least a couple of days to.
Did you
adequately prepare.
did you just send that to us, or did you e-file it?
It was
And
e-filed, I don't know if she
and-
tagged, I mean, I don't do that.
you got to make sure they have notice of that. So at this point, what I'm going to do, hold on just a second.
She is present. though.
And we're not prepared for it.
Yeah, but they haven't talked to her or prepared for anything.
I don't understand why they didn't get a copy of the list if it's been filed.
Well, it was
It wasn't a motion.
a
No, there's motion.
letter.
There's a motion filed.
We have neither a motion or a letter in the file.
Well, that's their problem, Your Honor. I mean, that's not mine. He's in jail. I mean,
Well, if it was e-filed and sent to the correct people, then I don't know that it's necessarily their problem or an electronic problem or a problem that your office didn't send it to the right person. So we're not,
but it was e-filed. My point is it's on file with the clerk. It's on file.
the state has to be aware of it. Just hang on a second. I see that he's in jail. It's a jail docket. I also have some concerns whether she's here or not with what was going on, because just because she says she doesn't want to prosecute doesn't mean that I think she's safe with him doing what this allegation is after he was trespass warned from going over there. Yeah, I guess when you do need to make sure, I guess I have it from the 18th, a request for reasonable probation bond and speedy probation hearing comes now, blah, 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 asking for it. An order was attached as well. So somewhere it got either lost or something wasn't done correctly one way or the other. Doesn't matter at this point. We're here. My bigger issue is probably the same issue that the state's going to have. I want them to have time to talk to her. If she's going to file something and it changes the status of this, then we'll deal with that at that time.
She has filed a non-prosecution.
You have that in the file? Okay.
Just, and one final thing I'll say on this is, it's one thing to file, e-file something, but it's a whole nother thing to make sure that you hit the tab or,
I've gotten there too.
yeah,
I've already
initiate
said,
service.
I understand, and that's what I'm saying. If the right service wasn't sent, then it's an issue on your side that they didn't get it. Make sure it's done correctly,
To Ashley. I mean, you can see on the e-file notification.
that it was sent to her.
To Ashley.
Okay, so it was sent. Is it gonna show up here? It says it was,
Let me show you. This is what he filed in the original case, and then they re-indicted the case in the bond, switched over to that one.
so can we get this to show up now in the original? I mean, in the new case?
I can ask, him to either redo it, or I can, yes, ma'am, I can get it in there.
Okay,
I will do that.
okay, let's see. You are Gabrielle Smith? Stand up, please. And this is cause number 25, DCCR 0979. Ms. Smith is charged with assault on a peace officer from June 10th of 2023. And Mr. Kimler has filed a motion asking that I reduce the bond, which is currently at $40,000, correct?
Yes.
Ms. Smith, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Kimler.
Gabrielle, what are your financial resources right now before trying to post a bond?
Speak up where I can hear you.
Well, I have one.
Hang on a second. I need everybody to keep it down, please, because I'm having trouble hearing. Speak loud and clear.
I have one family member that could probably help me, but I don't have one. I've been in jail a year, so really nothing.
How long?
A year.
A year. And is that waiting to go to trial?
And guess what? Just here. Ready to get my charges, I guess, decided.
Do you think that you could post a $5,000 bond?
Yes, sir.
Can I see, has the other case been dismissed? Can I open that one up and see what all's been filed in it?
Two, three, yeah, that 2, 3 D, 1030.
Like, such a big copy of the middle box. Okay, let's,
3 times since that, we got, at least anything.
so it looks like okay, there was back in February of 2024, there was a bond forfeiture. And so the bond was raised because of that. Then it looks like there was a motion for me to reduce the bond, which I did. In October of 2024, I reduced the bond to $10,000. And then
She did enter the plea, Your Honor. It
Entered-
said PSI bond.
I did
That
at
plea was
one-
Rejected by the court.
okay. The bond was reduced to 1,000. There was a plea. And then
So there's a plea and then it was reduced, I guess. Or-
for PSI, I reduced it to 1,000. And then appears as though in February of this year, I'm trying to figure out exactly why I increased it to 40,000. Hold on, let me just figure out.
Wasn't sufficient.
Okay, and then, let's see, let me look at this PSI, that'll give me some information. So the agreement was for a cap of 5 years, which is unusual that I would have reduced that to $1,000. So I'm not sure I understand why I did that in the first place when it was a cap, but I did for some reason. And that pre-sentence report,
Court
She-
revealed 9 convictions, felony convictions from Louisiana, Your Honor. That's why you rejected that.
right, and several misdemeanor thefts and a revocation. Been to prison in Louisiana. Yeah, as recently as 18. Okay, so I rejected that plea agreement. So the bond is currently set at 40,000 on a robbery with that criminal history. Okay. Mr. Nichols, what is your position with regard to bond?
With her criminal history and the allegations in this case of assaulting an officer while she was trying to steal from a store, I think 40,000 is right where it needs to be, Your Honor.
Mr. Kimler?
I've read the probable cause affidavit. I don't think that she could actually be said that she actually assaulted the officer directly. There is a fact situation that could perhaps be fitted into an assault charge. But as far as just out and out striking or assaulting an officer, that wasn't the fact scenario. Involved a vehicle. I think the officer had leaned into it and then the vehicle went into motion. And,
Well, how did the vehicle go into motion?
Well, that's the defense, I suppose.
Hold on, let me look at the PC.
Well, it's not like she hit an officer or hit an officer.
She scratched at him while he was trying to stop her driver from trying to leave, Judge.
She was flailing about, I suppose.
So over here in a car, with a paper tag from Louisiana, which is where all the other criminal history is. That motion's denied.
Okay, we've got a speedy trial, I guess, so we can get it tried.
And the 252nd, everything's speedy.
All right,
It will be placed, I mean, is it, it wasn't on the trial docket. I mean, if you want to do a rejection, if you've done all
well,
the,
I guess if the court has rejected the plea offer, then the 5-year cap.
do y'all want to negotiate any other? Do you want me to just move it to the trial?
Take 8. Take 8. You want me to do a rejection?
Yeah, if you'll do a rejection of whatever that offer is, that way I have a paper trail of why it's on the trial docket. Goodness gracious. Mr. Matusko, you've got Xavier and Garner.
Yes, sure.
6 cases. Oh, I don't have, hold on, let me recall that in just a second. Do you have some stuff coming through on Garner? I've got a registration, but I don't have anything else. All right.
Then I'll need to cattle judge up in here.
Okay, that's okay. I'll hold it for just a second. Thank you. That's gonna be a good one. Get rid of 6 cases. Mr. Parker, you've got Jacoby Judge.
Can't remember what I've done on
I know, I just looked up and I've got a line of things ready, which is good. Yeah. Good morning. Are you Jacoby Judge?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Judge, in cause number 24 DCCR 1174, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 17th of 2024 for the offense of obstruction or retaliation, a 3rd-degree felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to provide verification of attending the SafeP program. Is that true or not true?
True.
And then count 2 alleges that you failed to successfully complete the SafeP program. Good grief. These are a mess.
I don't know why they phrase them like that, Judge. I mean,
All right.
He did it twice.
Okay.
Good.
You didn't complete the SafeP, you didn't complete the SafeP program, right?
No.
Okay. Did you enter your pleas of true to counts 1 and 2 freely and
Yes,
voluntarily?
ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number
No
1.
objection?
It's admitted. Is there any evidence that Mr. Judge is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of obstruction or retaliation and sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I've handed you the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
It's on there, it's not real heavy.
Warren Mills,
Judge, I'm
Mr.
gonna ask, we reset that a couple weeks. We've had issues with the video. I've got the video and I need to go with him. He wants to talk to his
Okay.
family.
All right, we'll just do maybe about 3 weeks on
That's fine.
Mills.
Third Street, I believe.
Shaniqua Washington,
Third Street, Lane.
morning. Good morning. Are you Shaniqua Washington?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Washington, in cause number 24, DCCR 2370, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from September 29th of 2024. The indictment alleges you were previously convicted of theft April 7th of 2010, and then again July 12th of 2012. And how do you plead to that charge? And are those 2 prior convictions true? Did you enter your plea of guilty freely and voluntarily? And because you actually did what they charged you with? Did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a deferred probation. How long?
3 years.
I'm sorry. Can y'all, any problem with me writing that in?
I wrote it. Well, maybe
didn't-
she
it didn't
probably
come
sent
through.
She sent it before.
3 years. Okay, so a 3-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Is there any restitution, or were the items
They were recovered.
recovered? Okay. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Washington's not competent?
You're right.
Other than those 2 that are listed, do you see other issues? or-
Judge, I see nothing but misdemeanors, so she's got misdemeanor history.
Okay,
We're asking waive for DSI.
We're okay with waiving it, or if the court wants one, we're okay with a PR bond.
yeah, I mean, if yours,
There is
This-
history.
there is, I mean, the last one that's listed here is 2012,
We've got some other charges other than.
That's misdemeanor.
other than deaths. Okay, all right, then I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find, did I print that? Do I need to do it again? I might not have. Okay, going to find sufficient evidence to find that you enter your plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification. That shows this was an agreement that I followed, so you waived your right to appeal. Probation's going to talk to you before you leave today. It's very important that as soon as you get out, you do everything that they're tell you to do, okay? All right, good luck to you, ma'am. Let's see, Kendrick Williams, 4 cases are called, Mr. Parker.
Kendrick Williams?
Your cases are gonna be on there, or whatever on this day, just say, just ignore it, you don't need to be working on it right now.
Okay, so we've
I
got,
didn't write CC on these cases, Judge, but
okay. That's fine. And are we going on, are there more than one count? Are we going on?
On the
I
motion,
did
Your Honor,
second degree.
No, are they all
Well, the
new
state jail
cases?
that's enhanced and
the state jail requires its enhancements.
That's the possession?
Yes, sir.
I-
Well, there's 2
I'm-
possessions, Your
I'm
Honor.
thinking about it.
No, the evading arrest and previous convictions.
I'm just now thinking I may have filled out the state jail paperwork wrong. I'm not positive, but I may have.
Just be patient with me as I pull it and then I'll
Yeah.
figure out what we need to do, if anything. Okay, are you Kendrick Williams?
Yes, ma'am.
And will your client waive the formal reading of the indictments and also the motion?
He will, Your Honor.
Okay, so there are priors listed, so it is count 1. I'm assuming,
Yes, Your Honor.
at least on the 1075.
But it's not needed. 1075 or 2352.
Okay, just 1076 today.
Yes, Your Honor.
Okay. In cause number 24, DCCR 1075, the state has elected to proceed on count 1 only. It alleges you committed the 2nd-degree felony offense of possession of a controlled substance from February 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? Give me just a second. In cause number 24, DCCR 1076, you're charged with a state jail felony offense of evading arrest or detention with previous convictions. And is he getting state jail time on
No,
this?
that's what I think. I
So we
filled it.
need all of them.
Yes.
Did you do state jail paperwork?
I don't remember. I'm thinking I've had in state jail paperwork. I've got this one up here. I've redone it. I just don't remember if I did or not.
Okay. So the offense date on this is from February 19th of 2024. The indictment alleges you were previously convicted of evading arrest or detention September 26th of 2007. It further alleges that you were previously convicted of possession of a controlled substance, a state jail felony, September 24th of 2007, and also possession of a controlled substance, a state jail felony, September 4th of 2012. And how do you plead to that charge? And are all of those prior offenses convictions true?
Yes, ma'am.
Okay, let me make that note real quick. This is so much better than paper. Okay, and then in cause number 24, DCCR 2352, you're charged with the second-degree felony offense of injury to a child, elderly, or disabled individual from July 19th of 2024. So that's already a second. Are we going on to the other counts as well,
We
or
don't
no?
need to, Your Honor, just count one.
So in that count one only, how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? In all three of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in those 3 cases.
No objection, Judge.
It's admitted in each of those cases. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in cause number 24 DCCR 1075, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You did it right.
I did?
Mhm.
Okay.
In cause number 24, DCCR 1076, I'm also going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And in that case, find you guilty and find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2352, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, let me get the MTRP pulled up.
And Judge, counts 1 and 2 include some of the cases we just pled to. The third one was not yet added as an amendment, but since we had an agreement, we just go on 1 and 2.
1 and 2, okay. All right, in cause number 21, 36841, I have a motion to revoke your community supervision. It shows that you were placed on probation October 13th of 2021 for the offense of assault on a peace officer. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense that we've already talked about of evading arrest or detention with previous convictions, February 19th of 2024. And is that true or not true?
Yes, ma'am. Sure.
And then count 2 alleges that you committed the offense of possession of a controlled substance, February 19th of 2024. And is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're both actually true?
Yes, ma'am.
I also have here on the computer in that case some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these papers with Mr. Parker?
Yes, ma'am.
And do you fully understand them also? And you understand if I follow this agreement, you will be waiving your right to appeal.
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You will, these cases will all run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows that these were agreements that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank y'all. What you need? Y'all need some? Yeah, I can just give me this.
Yeah, he don't, new cases invited.
Okay. Bailiffs already know. Okay.
Damn.
It's reset if he's here. Just.
Amanda Arendt.
Judge, we're gonna, that's, the state is asking that we reset that. This is Ms. Maltino's case. She's trying to talk to somebody about, I don't know, to give me an offer.
Okay,
She's asked us to reset.
we'll just do one normal reset on that. Kyla Allen, it's a sentencing, Mr. Parker.
Yes, Your Honor. What I do.
And that's where this courtroom session comes to an end, but the consequences are only beginning. One defendant walked out with another chance, but the judge made one thing brutally clear: mess up again, and prison could be next. Then we saw another defendant reject a major plea deal and choose to take the fight to trial, knowing exactly what could be waiting on the other side. These moments show just how quickly a courtroom decision can change someone's future. A second chance can be valuable, but it also comes with responsibility. So, what do you think? Did the judge show the right amount of mercy, or should the hammer have come down harder? Drop your opinion in the comments, and if you want more intense courtroom moments and legal breakdowns, like the video, subscribe, and turn on notifications. Thanks for watching, and remember, in court, every decision matters.